Good afternoon, everyone, and welcome, and thank you for joining us for the Making It Real, What the Supreme Court's Fisher Decision Means for Medical Schools webinar. I'm Amy Adams, the lead engagement specialist with the AAMC Holistic Review Project. We'll get started with the formal program in a few minutes, but would first like to go over a few housekeeping items. You'll be listening to today's webinar over your computer speakers. You'll not dial into a teleconference line. To communicate with your webinar moderator and panelists, as well as with each other, please use the panels in the navigation bar located on the right side of your screen. There are 4 panels. We'll only use the polling, Q&A, and chat features during today's webinar. To use a panel, simply click on the triangle in the blue bar to expand it. Clicking the arrow again will collapse the window. You can expand or collapse any of the panels at any time. So periodically during the webinar, we'll introduce a poll in the main screen. To respond to a poll, use the polling panel. We posted a question there now. Please take a moment to respond, then submit your results using the button in the lower right corner. So we're just interested in knowing whether your institution is public or private. Great. Once everyone has had a chance to respond, we'll display the results. The responses to poll questions are anonymous. We'll only see and display the aggregate results. To ask questions of the panelists during the webinar, use the Q&A panel. Type your question, select all panelists in the lower portion of the box, and then hit send. If you didn't have an opportunity to submit questions in advance, why don't you use the Q&A panel to submit them now or at any time during the webinar. Okay. We'll try to address as many of your questions as we can today, and then we'll post the responses to questions we are unable to address on the Holistic Review Project website after the November annual meeting. And we just want to let you know that we won't be identifying the names of people who submit questions. We'll also use the chat feature today. Use this feature like you would a live Twitter feed, a place to share insights and takeaways with both your colleagues and the panelists throughout the session. To chat, type your message, then select all participants from the very bottom of the drop-down options, and then click send. So why don't we try this now? Type what AAMC region you're in into the chat panel. And again, select all participants from the drop-down menu and click send. Great. From what I'm seeing, it seems like folks have the hang of this. Just so you know, we're unable to answer questions from panelists that are posed in the chat panel today. However, we will include them in the responses we post to AAMC.org after the annual meeting. If you're experiencing any difficulties, please send us an alert in the chat panel. We'll do our best to support you. If at any time we lose the audio feed or the entire connection altogether, we'll try our best to get the webinar back up as soon as possible. So thank you for your patience and for joining us. And with that, I'll turn it over to Henry Sontheimer, the moderator for today's webinar.
Thanks very much, Amy. I would like to welcome everyone to our webinar on exploring the legal and policy implications of the Supreme Court's Fisher versus University of Texas at Austin decision. I'm Henry Sontheimer, Senior Director of Medical Education Projects here at the AAMC and the Director of the AAMC's Holistic Review Project. For those unfamiliar with the Holistic Review Project, it works with and through the medical schools to build a diverse physician workforce capable of and committed to improving the health of all. Guided by a national advisory committee, the Holistic Review Project assists medical schools in establishing, implementing, and evaluating mission-driven admissions policies and practices. Our panelists for today's webinar are Heather Alarcon, Senior Corporate Counsel here at the AAMC, Art Coleman, Managing Partner at Education Council, LLC, and Jeffrey Young, the Senior Director of Student Affairs and Student Programs, also here at the AAMC. The Fisher decision provides medical schools with an important opportunity to reflect on existing practices and to develop effective and lawful policies and programs to achieve their mission-based diversity goals. We hope that this webinar will seed a national conversation about how medical schools might use the Fisher decision to inform action and facilitate conversations on your campuses. Here's a quick overview of the goals for today's webinar. First, we will provide a concise, clear overview of the court's decision. Then, we will discuss the policy implications of that decision for medical schools and others in the health professions education realm. And finally, we will explore strategies with you for turning these implications into action planning and implementation at your school. Leading up to today, we encourage you to submit questions and concerns you wanted us to address on the webinar, and we're very appreciative of those of you who have already submitted questions. Please continue sending questions throughout the webinar using the Q&A panel that Amy Adams just described. We'll do our best to answer as many of these questions as we can today, and we'll log in those that we do not respond to on this webinar. In addition, we'll post the responses later on our Holistic Review Project website after the AAMC annual meeting. Now let's get started. Before we dive into the decision itself, I'd like to ask Jeffrey Young if he could please tell us why the Supreme Court's decisions about race-conscious admissions are so important to the AAMC.
I'm happy to do so, Henry. As many of you know, the AAMC's mission is to serve and lead the academic medicine community to improve the health of all, and diversity plays a critical role in achieving that mission. But we don't pursue diversity for diversity's sake. Instead, we see diversity as a means to the goal of enhanced access to health, high-quality, compassionate, patient-centered care, and improved health outcomes. Improving the quality of and access to care for an increasingly diverse patient population requires physicians who, 1, can work as part of collaborative teams, and 2, who have effective cross-communication skills and strong complex problem-solving skills. These are abilities and skills best fostered in learning environments that engage diverse student populations. I also want to make the point that achieving this goal involves everyone in academic medicine. Building and nurturing a diverse physician workforce committed to addressing the nation's healthcare needs cannot be the responsibility of just one office or function. This is why, even though the Fisher case focused primarily on admissions, we encouraged every medical school to create and participate in this webinar as cross-functional institutional teams. This work really does require an integrated and coordinated effort across the entire institution. So let's just take a moment here and pause to conduct a poll. I'm curious to know how many in our audience are participating as part of a team today. By way of a reminder, select and submit your responses to our question using the polling panel located in the bottom right corner of your screen. Wow, it's great to see so many folks participating as part of the team today.
I agree, Jeff, and I'd just like to add that the overarching goal here is to achieve educational excellence and prepare a physician workforce for the 21st century. As we explained in our amicus brief for the Fisher case, there's well-documented and significant disparity in health outcomes based on race and ethnicity, and that ultimately drives much of our work in this area. Before we go further, I want to note that diversity, as framed by the AAMC and defined by each of our member institutions, encompasses a wide range of experiences, attributes, and academic metrics. These often include, but aren't limited to, race and ethnicity. However, the Fisher decision and this webinar focus explicitly on race and ethnicity. I also want to clarify that, for the purposes of today's webinar, the terms race and ethnicity are going to be used interchangeably, as those terms are interchangeable under federal non-discrimination law. A number of states have passed bans on the consideration of race at their public institutions of higher education. I want to be clear that we're focusing on federal standards today. The parameters of the state bans are beyond the scope of our discussion here. Finally, I want to make clear that the views expressed here should not be construed as institution-specific legal advice. We're attempting to provide a global summary of key points and perspectives to inform institution-specific discussions and ongoing work in this area.
Thanks, Jeffrey and Heather. Heather, could you refresh our memories with a very brief description of the facts underlying the Fisher case?
Sure, Henry. So in brief, the Fisher case involved a challenge to the University of Texas at Austin's use of race in its undergraduate admissions policy. Abigail Fisher, a white woman, sued UT after being denied admission, claiming that the university's admissions policy discriminated against her on the basis of race. So UT's admissions policy has two components. First, under state law, Texas students who graduate in the top 10% of their high school class are guaranteed admission to a University of Texas campus, though not necessarily the campus of their choosing. The top 10% rule accounts for the overwhelming majority of applicants admitted to UT, and as a result of the top 10% rule, more than 20%, I want to say it again, of the incoming freshmen at UT were underrepresented minority students as defined by UT Austin. That's African American, Hispanic, and Native American students. Second, UT evaluates that small number of applicants who didn't come in under the 10% rule, and that would include Abigail Fisher, and these are the ones over whom they exercise some discretion. They used a holistic review process, and that process included a consideration of racial background as just one factor among many. The central issue in this case was whether the university needed to consider the race of the remaining applicants when, in relative terms, it already was admitting so many underrepresented minority students. If anyone wants a more detailed explanation of the case, we encourage you to listen to the AAMC's Pre-Fisher podcast or read the College Board's Access and Diversity Collaborative Guidance on the case. Those references can be found at the end of this webinar and are also available on AAMC.org. Ultimately, Fisher's challenge was twofold. First, she argued that UT's consideration of race did not meet the existing legal standards set forth in the Supreme Court's 2003 decision in Grutter and Gratz. Second, she argued that if UT did follow those requirements, the Supreme Court should reconsider that framework.
Thanks, Heather. Art Coleman, can you give us a quick refresher on the Grutter framework?
Sure, Henry. In a nutshell, any classification based on race or ethnicity, including admissions policies but other enrollment-related policies like financial aid and scholarships as well as student support policies, must meet the highest standard of judicial review, and this standard applies both to public and private institutions. To meet this strict scrutiny standard, a school must be able to establish, 1, that its uses of race serve a compelling interest, the ends, and 2, that its race-conscious policy is narrowly tailored, legal term, to meet that interest, the means. The Grutter case laid out a framework to meet this standard, essentially requiring that the school be able to answer all 5 of the following questions in the affirmative. 1, with respect to ends, is there a compelling interest that justifies the use of race in the first place? And if there is, with respect to means, 1, is there use of race necessary to achieve this compelling interest? Then, is the use of race sufficiently flexible? Does the use of race minimally burden non-beneficiaries of the policy? And finally, is the school periodically reviewing and evaluating its use of race, refining practices over time in light of that review?
Now, Art, in this case, UT Austin believed that it could answer all 5 of those questions, right?
That's correct, and the lower courts agreed, upholding the UT Austin admissions policy that was challenged.
So now, a central question before the Supreme Court was the Fifth Circuit right in its application of Grutter standards to the facts of that case?
How did the Supreme Court respond, Art?
Here's the thumbnail version of the outcome. In a 7-to-1 decision, somewhat surprising to us court watchers who expected a closer call, the court didn't actually rule on the merits of UT's admissions policy, That is, they didn't decide whether the university was correct in answering yes to all 5 of those questions. Instead, the court sent the dispute back to the Fifth Circuit because it found that the Fifth Circuit hadn't faithfully applied strict scrutiny principles pursuant to the Grutter case when reviewing UT Austin's practices.
So Heather, this means that the court didn't change the 5 questions, right?
That's fundamentally right, Jeff. The Fisher decision preserved the existing framework with some clarifying emphasis. It clarified where the court may and may not give deference to a school's educational judgment, and emphasized that the burden is on the school not just to say yes to those 5 questions, but also to be able to prove it. I'll use the metaphor of a 4-legged stool to break this down. So the seat represents a school's compelling interest that justifies its use of race. We'll set this apart because this is where schools may receive some, but not complete, deference from courts regarding their judgment that diversity is essential to their educational and professional missions. And in that sense, the court lets stand 35 years of precedent that has upheld the educational benefits of diversity as a compelling interest when tied to a school's mission. These benefits include enhanced teaching and learning opportunities, better preparation for the 21st century workforce, and improved civic engagement. For many medical schools, the compelling interest might be grounded in mission-based professional goals, such as fostering a physician workforce that's capable of and committed to serving our nation's healthcare needs and caring for an increasingly diverse, stratified, and aging patient population. The seat, the compelling interest, represents the ends. The means to that end is your race-conscious policy, and the legs of the stool are the prerequisites for that race-conscious policy. If your policy can meet these requirements, if all 4 legs are in place and are customized to fit the size and shape of the seat, your stool won't fall over, and your policy should withstand judicial scrutiny. I separate the seat, the ends, from the legs, characteristics of your means, to help clarify where the court will give deference to a school. In the Fisher decision, the court clearly stated that deference does not extend to the means a school uses to attain student diversity, that's the legs. Instead, the institution must demonstrate to a court that its methods are narrowly tailored to meet its stated goals. I'll take each of these 4 legs in turn. First, a school needs to be able to show a court that its use of race is necessary for it to achieve its compelling interest. To do this, a school will need to show that it has considered or used race-neutral strategies, but found that alone they weren't sufficient to achieve its compelling interest. A school is likely also going to need to be able to show that the use of race is having an impact on helping to achieve its compelling interest. In other decisions, the courts indicated that if your policy is not, in fact, making an impact on your compelling interest, then logically the means are not narrowly tailored to meet the ends. Second, a school needs to show that it's using race flexibly, no quotas or no rigid or mechanical use of race. Race should be one of multiple dimensions of diversity that's considered. Third, the burden on non-beneficiaries should be minimal. Essentially, this means that in helping one class of people, you're not unnecessarily burdening others. Finally, a school's use of race needs to be periodically reviewed and evaluated. This review and evaluation enables you to demonstrate how you're addressing those other legs of the stool, but it also shows your commitment to only use race where absolutely necessary. A school with a regular process of review and evaluation is well positioned to establish that it does not take lightly its responsibilities in considering race.
This is very helpful when explained this way, but I don't see holistic review represented anywhere in this illustration. Art, can you help us understand how does holistic review fit into this picture?
Sure, Jeff. Let's return to the stool and see that holistic review is represented by 2 legs of the stool, flexibility and minimal burden. Here's how. Authentic holistic review considers race in a flexible manner as one characteristic among many, without quotas or rigid numerical values assigned to race. Where race is considered amidst a wide range of experiences, attributes, and metrics, the use of race, therefore, should minimally burden non-beneficiaries. And that's why, incidentally, we think the EAM model is such a powerful visual that can capture foundations for institutional practice. As such, individualized holistic review, as framed by the AAMC, remains a best practice model in admissions for medical schools to consider and adapt as appropriate in light of their mission-based goals.
I think it's worth noting that the points you've both made are embedded in the AAMC's 4 core principles of holistic admissions. First, your diversity-related policies and practices should cascade from the institutional mission. The second core principle, policies, practices, and admissions criteria should periodically be reviewed and grounded in institutional data. The third core principle, decisions should take into account the future contributions an applicant might make to the educational environment and medical practice. And finally, race and ethnicity should be narrowly tailored and just two of a broader mix of factors considered.
Thanks, everyone, for that helpful overview. Amy Adams, do we have any questions from the participants?
We do, Henry. I have two questions that we've received in advance. So, Art, I'm going to pass the first one to you. Are there any gender-based considerations as a result of the Fisher decision?
So, Amy, I'm going to give you a classic lawyer's answer, yes and no. As a technical matter, the case did not address gender or sex-based preferences or considerations in admissions, and so the court did not speak directly to gender-based considerations. That said, the legal standard that applies to sex-based classifications is one small step from this rigid, tough, strict scrutiny standard that's been described previously. It's an intermediate standard of review, but it fundamentally poses the same kinds of questions. What are your ends, and do you have a policy design that is fundamentally set up to achieve those ends successfully without over-reliance, in this case, on gender or sex? And so there are implications coming out of this case that should affect the way institutions think about the issues associated with gender-based considerations, and the question of necessity is also one that's...
Great. Thank you, Art. Heather, could you please answer the second one for us? What, if any, is the effect of the Fisher decision on states that have laws prohibiting the use of race, gender, etc. for admissions decisions?
To put it most simply, it doesn't. To the extent that your state has these prohibitions that go beyond what's permitted under the framework that's put forth before the court, this wouldn't affect the way that you do business.
Great. Thank you, Heather. And also, just like to remind folks to please submit your questions using the Q&A panel. We'll try to answer them today. If not during the webinar, then on the Holistic Review Project website after the annual meeting.
Let's just pause for a minute here. I'm curious to know what our participants are thinking at this point. We have a couple of questions for you. The first is, how important is the consideration of race and ethnicity in admissions at your school in the context of its mission and goals? And I'll give you a minute or so to answer, so take your time. I'm not sure if you can see the results, but here we can see that overwhelmingly people chose A and B, either very important or somewhat important, and we'll work these into our slides for the presentation at the annual meeting in Philadelphia. The next question is, how concerned are you about additional court cases challenging the use of race and ethnicity in admissions and enrollment decisions at your medical school? Great. Thanks again. And again, Your answers are very strongly in the affirmative, A and B, very concerned or somewhat concerned for over 90% of you. These are very interesting results. We're going to switch gears at this point and get to the topic that's on a lot of people's minds. You laid out what a school needs to consider theoretically in order to still use race-conscious policies and practices, Jeffrey and Heather and Art, but how will medical schools actually do that in ways that will satisfy the courts going forward? Art, if you could start with that.
I'd be glad to, Henry. Let's talk about, going back to the stool, the necessity leg of the stool, because this was the area of the court's principal focus in its decision. To demonstrate necessity as a foundation for race or ethnicity conscious policies and practices, a school needs to be able to show that it seriously considered and, where appropriate, used race-neutral strategies, but found that they were alone inadequate to achieve diversity-tied compelling interests. As we've discussed, the court has long said that race-conscious policies can only be used where necessary to achieve their goals. In Fisher, the court reemphasized that schools need to show a serious consideration of race-neutral alternatives in this context. Specifically, the Supreme Court said that an institution must be able to demonstrate to a court that, quote, no workable race-neutral alternative would produce the educational benefits of diversity. In other words, quote, if a non-racial approach could promote the substantial interest in diversity about as well and at as tolerable administrative expense, then the school may not consider race. The court also noted that narrow tailoring does not require exhaustion of every conceivable race-neutral alternative, but does require, when a court reviews it, for a court to examine each case with care. In the court's words, whether a race-neutral approach could promote the substantial interest about as well as a race-conscious approach and at tolerable administrative expense is a key inquiry under Fisher, informed by the institution's, in the court's words, experience and expertise in adopting or rejecting certain admissions processes. The bottom line here, and this is an important point of emphasis, is that while in the headlines and sometimes even in the court cases, the issues are seen as race-conscious versus race-neutral, they should be considered as potentially complementary strategies as institutions work to achieve robust diversity in multiple ways.
Art, it might be helpful to have some examples of race-neutral strategies as schools begin to think about how to apply these requirements.
Sure, Jeff. Let me give you a few examples of policies that may qualify as race-neutral and serve to achieve diversity goals, including those associated with race and ethnicity diversity. In the admissions context, there are numerous factors that may correlate with racial and ethnic diversity and that may yield some benefit for particular schools, such as those focused on low-income status, first-generation medical school attendance, and the like. In the same vein, schools that employ inclusive outreach and recruitment practices, even where there is an element of racial and ethnic focus, if the actual practice around outreach and recruitment is inclusive, part of a bigger pie, if you will, then those practices can be viewed as race-neutral in an effort to achieve diversity goals. And in a similar vein, scholarships and financial aid targeted to students who will bring certain values and backgrounds and experiences to the campus that correlate with race may be a foundation for race-neutral strategies to be considered as well.
Thank you, Art. And Heather, just to clarify, this isn't a new requirement, is it?
No, it's not a new requirement. In fact, if you look at the Fisher decision where they're talking about the consideration of race-neutral alternatives, they're quoting a lot of their language from Grutter. But I think it's worth noting that this is an area of emphasis and clarity, that this is a high bar, but it's surmountable. And the critical piece is documentation. You have to be able to document that you conducted a serious review of your policies and programs and systematically reviewed and evaluated the status and progress of these policies. That you're already using race-neutral strategies such as recruitment and scholarships as appropriate. And in addition to these race-neutral strategies, you pursue race-conscious policies and practices only to the extent necessary.
Thanks, Heather. We're interested in learning a little about what you, our participants, are doing at your schools currently. Again, we have a couple of questions for you. The first is, does your school consider an applicant's race and ethnicity in its admissions decisions at this time? Can we open that up a little longer? And the answer there was overwhelmingly in the affirmative. The next poll question is, does your school consider race and ethnicity in other enrollment-related functions, such as outreach and recruitment, financial aid, and support and retention practices? Once again, the response is overwhelmingly in the affirmative, with about 91% responding A or yes to this question. Before we go on, let's take a moment to check in with our participants. Amy, have we received any additional questions?
Yes, Henry, we've received some fantastic questions. So the first is, if race can be used in a holistic review admissions process, how is it possible not to assign a numerical value or weight to it? Art, would you like to, or Heather?
I can give it a shot. I think the key word is flexibility. For some people, their racial background is going to be so intertwined with the value that they can offer the medical school community and the health profession that it's going to be more important for that applicant. And for some people, the racial background isn't going to make much of a difference to the value that they can add. So I think that that's the important piece, is that the emphasis that you put on a person's racial background should be flexibly increasing or decreasing depending upon other factors and in their application and their attributes. Art, do you want to add anything?
Just to supplement with a good illustration and model, actually going back to Grutter, if you look at the court's opinion and the description of the law school practice there, it described that consideration of factors that went into a nuanced but not numerically based policy and practice. That policy verbatim, which in my experience is a really, really strong admissions policy that can be a guiding model for institutions of all sorts, is on the Access and Diversity Collaborative's website in a models publication, and I know we'll get to that site later.
Great, thank you both. Another question, can sexual orientation or religion be considered as grounds to increase diversity in the student body?
I think there are multiple factors that can include these as you look at issues. The court has not settled in clear terms just how, in recent days with court opinions, sexual orientation could or should be valued or factored under the court's analysis, whether it's strict scrutiny or something less. But I think in the mix of things, institutions often do look at that multiple array of factors, and so it's part of that broader diversity mix.
Great. Okay. And here's another one. So it sounds like the state law supersedes the federal decision to affirm. Is that correct? In cases of using race and ethnicity in admissions?
So where the federal courts have said the consideration of race and ethnicity is a permissible consideration of race in the context of pursuing diversity-related interests per Grutter, Gratz, and now Fisher, when state laws say, as they have in a number of states, as to public institutions, and all of those laws apply only to public institutions, that those institutions may not consider race as a matter of public will. then those state laws trump that particular rule. I think it is important to note in this context there is a case where oral arguments were heard yesterday challenging the constitutionality of those rules. And so yet again the Supreme Court is going to, or is expected to render a decision this term about the lawfulness of those state voter bans that began in California in the mid to late 90s.
And Art, just for the sake of our participants today, could you just name that case from yesterday and also teach us how to pronounce S-C-H-U-E-T-T-E?
You know, thank you, Henry. I so appreciate that. I've heard different pronunciations. We think it's Schuette versus Coalition to Defend Affirmative Action, but the important point is Henry spelled it, so you've all got the name. Oral arguments were heard yesterday, and the conventional wisdom, for what it's worth, coming out of those arguments is the court is not going to affirm the lower court's rejection of the voter ban in Michigan as unlawful. But that's nothing but tea leaf reading right now, and time will tell.
I think we have time for one more question. Amy, if you have one more at this juncture.
I do. So do Fisher principles apply to financial aid and race-based scholarships?
The short answer is, broadly speaking, yes. The court did not address financial aid and scholarships specifically, but the very strict scrutiny principles pursuant to the Equal Protection Clause that applies to public institutions, and Title VI of the Civil Rights Act of 1964, which applies to public and private institutions that receive federal assistance. That standard applies across the board, and for those interested particularly in financial aid and scholarships, the U.S. Department of Education published in 1994 Title VI Race-Conscious Scholarship Guidance that this department reaffirmed several weeks ago was still viable in guiding their judgments about Title VI compliance. But we do not have a U.S. Supreme Court decision addressing those issues of scholarships, and in fact, we don't have a Federal Circuit decision in the diversity context addressing scholarships. So it is a very sort of untested set of waters on that issue.
Great. Now that we've discussed some of Fisher's policy implications, I'd like to turn to our final topic of today's webinar. What action steps can the medical schools be taking at this time to help strengthen their position? Art, could you talk a little more about this?
Sure, Henry. I want to begin by emphasizing that the legal requirements highlighted in the Fisher decision essentially track and reinforce good educational practice, as surprising as that may be for some to hear. We know that medical schools are committed to continuous quality improvement, making it critical to know, first, whether what you're doing is necessary in producing the desired outcomes, and second, how you can use that information to improve your processes and practices over time, both in the short term and in the long term. I also want to stress the point that Jeff made at the beginning of this webinar. This responsibility does not lie with just one office or official within a medical school. Doing this work will require a coordinated, aligned effort from units across an institution. The Holistic Review Project's first roadmap publication, affectionately known here as the Red Book, lays out 4 action steps that remain relevant for schools: inventory, justify, evaluate, and act. First, inventory your policies and practices. Medical schools need to know what they're doing to achieve their mission-based diversity goals. And to borrow a term, schools should be doing a holistic review of all their diversity-related policies. They should focus as much on their race-neutral policies and practices as they do on their race-conscious policies and practices, a clear takeaway from the Fisher decision. As part of this exercise, schools should evaluate policies and practices to determine whether they are race-conscious, and schools should be examining race-neutral policies to determine both how they support diversity goals and how they might or might not be limited in their impact. Next, justify. A medical school needs to be able to document that it has considered and used race-neutral strategies and pursued race-conscious practices only to the extent necessary. As we've discussed, to be able to justify race-conscious policies that support diversity, a medical school needs to show that it uses race-neutral policies that support diversity goals in that context, or that it has at least considered the viability of those policies. Third, evaluate what you're doing. The medical school should demonstrate that it periodically reviews and assesses the effectiveness and impact of race-neutral and race-conscious practices. This doesn't include just reviewing written policies and program descriptions. It requires the school to look at how the process works in practice, another important point coming out of Fisher. In other words, a school needs to evaluate the effectiveness and impact of race-neutral and race-conscious policies over time. And finally, use those data to drive action. The school should make changes to its policies and practices based on the relevant evidence it collects and analyzes over time, reaffirming at core the strong educational foundations and decisions it is making as a foundation for legal compliance.
I just want to add that there are some additional AAMC resources that might be useful for schools as they undertake these conversations and action steps. The Holistic Review Project has 3 publications. Art already mentioned the first one that, again, we affectionately call the Red Book. And this book is explicitly about legal and educational policy foundations medical schools should be thinking about. And Art just very nicely reviewed some of those topics. The second lays out guidance for implementing holistic review. And the third focuses on evaluation frameworks and strategies. We strongly recommend that every medical school have an evaluation plan in place for its admissions and enrollment decisions. This plan should be predicated on the school's unique institutional mission and goals.
Thanks, Jeffrey. I just want to point out that all 3 publications are available free of charge on AAMC.org. At this point, Amy, do we have additional questions from our participants?
Yes, we do, Henry. One is, can you please comment on critical mass?
My comment would be we don't have enough time for me to comment on critical mass, but I'll give it a sort of brief whirl. I think critical mass, and we've not talked about it today, and it was in fact an issue that the court did not address in Fisher, even though it is a major issue in the case and an issue that we expect the Fifth Circuit to spend some time with when it rehears the case that's been remanded. Critical mass is best understood, 1, as a social science concept, not a legal term, and 2, as a contextual benchmark for gauging success with respect to diversity goals. So if you think about strategies leading to goals, the question is, how do you know success when you see it? And critical mass, as a foundation for that, basically says, do you have sufficient numbers of underrepresented minority students in this context so that you create an environment of robust teaching and learning where individuals do not feel like they are isolated and don't fully, as a consequence, contribute to the learning that is supposed to take place. There's an ample body of social science research behind this, and I won't go into further details. But it's important to note that it is an issue of some consternation and discussion, given that, frankly, we have as many questions as answers on that.
Great. Thank you, Art. Heather, how might a school demonstrate that a race-neutral strategy wouldn't achieve its goals? Does it actually have to try out the strategy and show that it doesn't work?
There's some debate around this. Personally, my take is that depending upon the strategy, maybe not. If there's a lot of research out there on a particular strategy, and it would show that it wouldn't work at the medical school level, at the graduate school level, part of the country that you're in, for example, I think as long as you document that you considered it, you document the reasons why it's not going to work, then you don't actually have to try something like, for example, the 10% rule, which we all know and the courts acknowledge wouldn't work for medical schools. You wouldn't have to actually try that. I think if it's tenable for your school, then you should give it a shot. If you go to write down the reason why it wouldn't work and you can't point to research or you can't point to a good justification, then I don't see a reason why not to give it a try. I think that you should think about these things not to be used in isolation or to replace the consideration of race necessarily, but to be used complementarily or use them together until you can get a set of tools that help you to achieve the student body that you want.
Great. Thank you, Heather. So, Art, here's another one for you. It's a fun one. Can we defend a lawsuit? Is there a checklist that schools can go by?
With a good lawyer, one can always defend a lawsuit. I think that the point here is, and I want to reemphasize the point I think Heather made earlier, while we talked a lot about a set of tough and probing questions, these are not impossible questions to answer. With a little bit of roll-up-your-sleeves effort, medical schools and other entities among institutions of higher education can achieve success. I think that I don't want to suggest that it's as simple as answering a set of questions on a checklist. It involves judgment. It involves integration of a number of factors. What I would offer is the Red Book as a foundation, and we've attempted to lift the sort of core questions around this strict scrutiny analysis, the questions centered on ends, and the four questions, the four legs of the stool tied to means. That's the framework for analysis. And I think that's the starting point to engage among institutional players who are responsible for achieving success on educational goals and doing so in a legally compliant way.
Great. Thank you, Art. And we just have a request for elaboration from a participant, and that's if you can just talk a little bit more about what's meant by compelling interest.
So the Supreme Court actually didn't define compelling interest in a rigorous way in the Grutter case. It basically looked to what the University of Michigan Law School said was its interest and then talked about the values behind that interest. What I can say, and what we do know very clearly, is for institutions that want to achieve racial and ethnic diversity among other kinds of diversity, and where they are using race and ethnicity conscious practices, such as in admissions, that compelling interest is best justified and is best articulated as a mission-oriented, forward-looking educational goal. And that's an important distinction from many of the race-conscious practices and issues of the past. This is not a remedial focus. It is an institutional focus around a core set of educational aims. And I think if you take a lesson away from Grutter and by extension Fisher, which did not focus as much on this precise question, what you want is a good, solid empirical foundation based on judgment and academic decision-making about the importance of diversity to your institution in very much the way that the AAMC publications have articulated the potential ways we think about diversity for the future of healthcare in America.
Great. Thank you very much, Art. Heather, a number of our medical schools have post-bac programs with strong historical commitments to improving access and increasing diversity in medicine, especially among underrepresented groups. Could you please talk some about the implications of the court's decision for these programs?
Yeah, these are great programs. I think the takeaway is that any classification based on race, any racial classification is going to be subjected to the highest scrutiny under the court. So the same sort of review that you're giving to your admissions program at the medical school level that at UT Austin and other undergrad programs are using at the undergrad level, that's the same type of analysis you want to do at the post-bac level as well. So any time that you're using race as a classification, you want to make sure that you can meet that strict scrutiny standard.
Great. Thank you, Heather. Jeff, we have one for you too. So how might schools think about and respond to the LCME standards on student diversity in light of the Supreme Court's decision?
Yeah, again, a great question. So when I think about the LCME standards that really address diversity, I think about IS-16, which fundamentally addresses institutional policies and practices to achieve diversity among its students, faculty, and staff, as well as retention of these populations. And then I think about MS-8, which really addresses programs or partnerships aimed at expanding diversity among applicants for medical school admissions. So I think everything that we've been talking about is all relevant. And so when you look at the Fisher case in a very strict way, ultimately you don't necessarily have to change as a result of the Fisher case in terms of trying to meet the requirements of the LCME standards. But again, I say that within the context of all the things that we've been talking about in terms of strict scrutiny, being able to achieve the needs and so forth, are all going to be relevant. Ultimately, it should be mission specific. We should be thinking about diversity defined broadly, and that it's not just limited to, for example, gender, race, culture, SES, or geographic region. What we should really be thinking about that the goal of, I think, the LCME standard, particularly those two that I mentioned, is really to help facilitate a learning environment categorized by and supportive of diversity and inclusion that enhances learning and prepares physicians to care for a diverse patient populations. So I think that's very critical. The last thing that I would just say is that, as we've been mentioning throughout today's webinar, there needs to be institutional alignment to meet the standards of the LCME.
Great, thank you so much, Jeff. So we have another question, which is asking if y'all could talk about today's topic, so the Fisher decision in relation to American Indian and Alaskan Native applicants, where there are considerations of federal sovereignty, tribal affiliation.
Yeah, so I'm going through legal cobwebs for a second. I think the basic rules are these. There is a justification for not subjecting Native American students to the strict scrutiny standard that applies to race and ethnicity. But historically, that exception has been very limited, almost so limited that it's been written out of the rule. I recall from my department days when the Department of Education put out the race-conscious scholarship guidance in 1994, it in fact did not recognize that exception. There are cases, however, that say when the preference is not based on an ethnicity, i.e. Native American status, but is based on tribal affiliation, by contrast, there may be a justification for carving that out of the strict scrutiny review, but I would say proceed with caution there because I think that opening is narrow at best.
Thank you, Art. And one additional question. Are there limitations on whether schools can give preferences to U.S. citizens over non-citizens?
I think the rules there suggest there are ways to attract students from other countries, but part of that gets to the design. Are you looking for a student who has experience in or brings a culture associated with a particular country or region as opposed to purely citizenship status? And I think those are lines that need to be considered in an area where I think, frankly, the Supreme Court has not clearly spoken in this admissions higher education context.
Great, thank you, Art. So we just got one more question. What meets the legal standard for a high bar to justify a race-conscious policy?
One more time, Amy.
Okay. What meets the legal standard for a high bar to justify a race-conscious policy? So if we've indicated that the bar has been raised.
Right.
Well, let me talk about where the bar has been raised, because I'm not sure that the bar was really raised on what the compelling interest was. I think really what the court was saying is continued deference and respect to the school's educational judgment of where diversity has an impact on the educational goals and mission of the university. So that's not where the bar was raised. The bar was raised on the burden on the school to demonstrate that they can meet that strict scrutiny standard. So earlier today, Art walked you through those 5 questions, and it's not enough for a school just to be able to say, we think we can answer yes to all those questions. The court here was saying, you have to be able to prove it. We want you to demonstrate it. We want to see evidence. And that's where the bar was really raised by the Fisher decision. I hope that answers the question.
That's fantastic. Thank you so much, Heather.
Well, thanks, everybody on the panel, and thanks, Amy. Vanna White, I'm sure, is rolling over in her grave now. She's going to lose her job. I know we're nearing the end of our webinar. I think it's worthwhile to take a few minutes to summarize the key points that our panelists have made today. The court's Fisher decision upheld the core principles of Grutter, but clarified and emphasized how courts should review what schools are doing. This means that courts may give some deference to the schools on their ends or mission-driven diversity goals, but not on the means by which they attempt to achieve their diversity. Schools in states without legal bans on the use of race and ethnicity can continue to use race-conscious policies so long as they can demonstrate that the policies are necessary, flexibly applied, place minimal burden on non-beneficiaries, and are subjected to periodic review and evaluation. The legal requirements we discussed today fundamentally track to good educational policy and practice. Holistic review, as framed by the AAMC, remains a legally viable and educationally sound policy and practice. Achieving individual institutional mission and working towards the shared mission of improving the health of all requires a coordinated and integrated effort across institutions. It cannot just rest with one person or one office. And diversity remains a critical element to achieving the overarching goal of improving the health care for all Americans.
So what I'd like to do at this point in time is just sort of share with you about AAMC's plans in this area. We will continue the national conversation with a session entitled Implementing the Healthcare and Diversity Imperatives in the Post-Fisher Environment at the AAMC 2013 annual meeting in Philadelphia. The session is scheduled for Saturday, November 2nd at 9:30 a.m. This thought leader session will not be a repeat of today's webinar, though it will build on the discussions and questions generated today. And just as a plug, there's still time to register for the meeting. So please visit our website if you haven't done so already. We will also post the responses to the questions we weren't able to address today on the Holistic Review Project website after the annual meeting. We will also be revising and updating the Holistic Review Project's publication, Roadmap to Diversity, Key Legal and Educational Policy Foundations for Medical Schools, this winter. And again, that's affectionately called the Red Book. And as already talked about very briefly, we will continue to monitor the legal landscape. And in fact, as Art alluded to earlier, we have some updates that we can share. And so while I'm not a legal person, let me see if I can walk through some of the changes and ask my colleagues to jump in as necessary. So here's the update on the Fisher case. We know that Fisher, the Fifth Circuit will hear arguments in Fisher on November 13th. It has asked the University of Texas and Abigail Fisher to answer 7 questions in their briefs, including questions about critical mass and race-neutral strategies. The Fifth Circuit has a number of options when it weighs in on the arguments. It could send the case back to the trial court, it could keep the case and rule on the issues, or it could dismiss the case because Abigail Fisher has graduated from college and it is not clear that she therefore has the standing to continue the lawsuit. And as Art indicated earlier, the Supreme Court heard oral arguments in the Schuette, Coalition versus Coalition to Defend Affirmative Action yesterday. This case involves a challenge to the state law ban enacted in Michigan in 2006 that prevents public institutions of higher education in Michigan from considering race in admissions. 7 other states have similar prohibitions. The Sixth Circuit Court of Appeals struck down the Michigan ban last fall, and the Supreme Court will decide whether state law bans like Michigan's are constitutional.
Thanks, Jeff. That's terrific. I want to say a few things before closing. The first is that we have recorded this webinar, and it will be posted within the next several days. We've had several questions in the chat room about that during the last hour. I want to start by thanking our 3 wonderful panelists, Heather Alarcon, Art Coleman, and Jeffrey Young, for an informative discussion during today's webinar. In addition, I want to thank you, our participants, for your questions. I thought the questions were terrific, and I really want to thank Amy Adams for handling those in real time. I'd like to also thank those who were instrumental in making this webinar possible, in particular Kate Lipper from Education Council, Liz White, our fabulous instructional designer, Angela Moses, Alex Tirico, and Hope Gray. We also want to acknowledge the work of the College Board's Access and Diversity Collaborative, which was launched in the wake of the 2003 Michigan decisions. Through the collaborative, the College Board works with core partners to provide sustained support for institutions of higher education and national education organizations committed to achieving access and diversity goals inextricably linked with career and citizenship readiness in the 21st century. More than 30 national universities and colleges and over 10 higher educational associations, including the AAMC, are institutional supporters of the collaborative. And you can learn more about the collaborative by visiting their website at diversitycollaborative.collegeboard.org. Thanks very much to everyone for staying with us. We've had over 130 people on the line through this webinar, and I'm very appreciative of everyone's interest in this very important case and the relevant cases to follow as we go forward here in the United States. Good afternoon.